Hello, everyone. It's Richard Fink, workers' compensation specialist lawyer, introducing you to the Injured Workers Legal Side podcast with Richard and Paul. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation and human rights law. If you want to reach out to either one of us and be part of one of our podcasts, you can contact us through the links below. This week's topic is the WSIB not listening to the advice of family doctors. Specifically, they're making it difficult for injured workers that are unable to work and demanding specialist reports and things like that. Is that basically it, Richard?
Yes. And let me go through quickly 7 cases from the Appeals Tribunal. So the Appeals Tribunal is the final adjudicative body in the workers' comp system. If you disagree with what the WSIB is saying, you go to the Appeals Tribunal. So there's a decision 60924 where the tribunal said that you should listen to the family doctor for 3 weeks when the family doctor says you're in an acute stage and you should be off work. Very typically, the WSIB will completely ignore this advice and say, well, you sprained your back. The employer's offering you some modified work where you don't have to lift anything. Go back to work. And if you don't, we're cutting you off. Decision 149723 says follow the family doctor if his advice is reasonable. So it doesn't have to be a neurologist, an orthopedic surgeon bringing forward an extra 6 years of experience in bones or nerves. It's where it's reasonable. Uh, in 125424, they said follow the family doctor's advice regarding a psychiatric disability. That's acceptable. So right now, to see a psychiatrist in the province of Ontario, there's a waiting time of about 8 months. You've got a psychiatric problem and you get fortunate enough to have a family doctor because 20% of the population in Ontario is even missing family doctors, but you have a family doctor who says you have a psychiatric problem. The board must follow the advice, at least in that case. 129322 says the family doctor should provide some reasoning when it says worker should stay off work. And the case that I read yesterday that's from June of this year, it's 22925, said family doctor said wait another 5 days before returning to work. And that's fine, even though the WSIB cut the worker off benefits for those 5 days.
But Richard, let's just go back to that 129322 when you said they said that the doctor should provide reasoning. And my concern with that is that, and I make direct reference to the functional abilities form. So if the employer or the worker or the board says, are you able to return to work? What are your functional abilities or medical restrictions or whatever they're calling it today? Because for every area, it seems to be very ambiguous, the term. So on the form, if you look carefully, it gives the doctor three options. The worker can return back to regular work. Great. Two, the worker can return to work with the following restrictions. Now, and you fill and it says go to the next section and fill it out. So the doctor does that and then signs it, gives it to the worker, and then they're fine. The one problem I have with that is if the worker has multiple issues, like if you have physical restrictions and then mental restrictions, as you were just saying, a psychiatrist, that if the doctor doesn't factor that in, then the board, if the worker is saying, well, I also have this, the board will exclude it, which becomes another problem. But we'll just put that aside for now. The other option, there's three options. The other one is the worker is not able to return to work. Check the box, and then it says skip over the next section and fill out that final section, which is the date, the next time you're going to see him, and sign it. Meaning Up until some point, the board would accept what the doctor said. They're a professional, they're an expert. And now they're saying, we don't believe anything you say, we want proof. I've even had it where the employer and the board both ganged up on the worker and said, well, the worker has to have some functional ability. And what I think they're doing is they're crossing lines. By this I mean if you can walk and breathe and move, as far as the employer and the board is concerned, you can work. But if you think about it, Richard, there's 24 hours in the day. Normally, most people, except for truck drivers sometimes, they sleep 8 hours, and then the other 16 is contributed to work and home life. And so, in other words, they're saying that if you have, say, a reduced capacity to function, they expect you to give all that capacity to work. And I'm like, wait a minute. You still have to do chores at homes and everything. And I think this is something that's missed by the board when they're deciding this return to work. Not to mention the fact that you're in an injury and you should be in a recovery phase. They should take it easy, and they're not. What do you think, Richard?
Well, take my own personal case. I went to my family doctor last week. He looks in my ears, says, "You have a lot of earwax. We got to drain it." And I'm a reasonable person. I will take his advice. He is a family doctor. He's got 10 years of experience as a family doctor, went to medical school, etc. If I was a WSIB, I'd say, no, 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 no. We need a report from an audiologist who specializes in ear, nose, and throat at Sunnybrook Hospital. And you don't miss any time from work because you're getting your ears drained next week. Back to work for you. And the question is, where did the case manager come up with the medical view that my family doctor's opinion that my ears need to be drained should be overruled? Like, if the family doctor says, I looked in the ears and I saw a lot of wax, that should be enough. If the family doctor says, I had the worker do some bending and twisting and looked at expressions and restrictions, I thought he should have another 5 days off work. Where does the case manager with no medical training at all come to overrule it?
See, I think the better question is not where do they get to overrule it, but what should be discussed is the proper way when they should be requesting or involving a specialist is the period of time, meaning not right away, but maybe at the time when the injury is becoming, is the worker isn't getting better or at a specific time. And the one thing I've noticed, Richard, and you might because you've been around for a little bit, but remember back in the 1990s was the board in their policy for permanent injuries, they had the usual healing time chart. And for example, soft tissue injuries
I
was
forgot
three
all about
months.
that chart.
What's that?
I forgot about the chart.
Exactly, because the board took it out so they can literally manipulate recovery and return to work with injured workers. It's a very devious thing they've done, because a worker sees it or a rep sees it and goes, okay, well, it's 3 months. You've reached this threshold. So now we either have to look at saying you have a permanent injury, escalating it to a specialist, whatever, for soft tissue. For other injuries, there's a bit more time. What I rely on when I do appeals is the 1 year threshold for, according to the AMA guides, whether it's the third edition from 1982 that the board uses or the more recent one, the sixth edition. And all say the same as about a year. If you haven't recovered in that period of time, you have a permanent injury. So at that point or in during that point, if there's no progress of recovery, then I can see the board saying, okay, well, it's been 3 months and you only have, say, a back injury or you have wax in your ears, Richard, and you're not getting any better for some goofy reason. We need to employ a specialist and then do that. That's fine. Or I'd like you to go see a specialist. And this gets onto another topic, Richard, and I'm not sure you're familiar, not getting off topic here, is that what scares me is the board is using its power to pressure workers to go see their doctors for treatment. And that's not allowed. It's one thing to say, well, we want you to go see a specialist to get an assessment. Great, let's find out what's going on. But they're not doing that. Like you always talk about, the board isn't taking care of the worker. How can we help you? And they're not doing that. And everything they do, there's this perception now the board is doing it to get you off, to cheat you, to steal from you. And this is a bad perception that people have of the board, meaning it's bad for the board. Because once everybody has it, the system will fail if it
Well,
hasn't already.
we can't use the word steal
Well,
because
what I mean is,
you're saying the board's committing a crime in a sense.
no, I'm not saying
They're
they're
not
committing a
stealing.
crime.
What they're doing is they're restricting your entitlements.
Yes. Yeah. I mean, that's the problem is that it's the perception of people. I'm not saying they're doing it. What I'm saying is people have this perception that they're not there to help them anymore. You know,
Let me
they're
go
not going to
back.
listen to your doctor. They're not going to get you to a specialist, and their goal every time is to force you back to work.
Let me
And
go back to this point of legal recompense. So, seven people had to go to the tribunal, and they were asking from 5 to 15 days of lost wages. So let's assume they're $700 a week lost wages. So some of them are going there for $500, $600, and some are going there for, say, $2,000. The cost in our office to take a case to the appeals tribunal is at least $2,000. So it's an absolute loss. Some of these cases are being done by private paralegals and lawyers, and some of them are being done by the legal clinics where the cost is irrelevant. But the point arises is why has no one thought of suing the WSIB for being malicious and malfeasance of public office in making this finding that GPs won't be followed, even though cases from the tribunal have gone back several years saying you have to listen to them if their opinion's reasonable. So it raises a question, which is there's all these areas in workers' compensation law and practice where things are being done quite improperly. And you can go to fair practices, but there's not much recompense or a way to turn it around.
yeah, fair practice is like the ombudsman for WSIB. It is actually. But whenever I've experienced them and trying to deal, to me, I think, in my opinion, an ombudsman or an auditor, somebody should act when either there's an individual serious extreme case of wrongdoing in process and saying, hey, wait a minute, you're doing this wrong. Or in general, when there's a systemic problem where there's a whole bunch. But what I've been told by them is, no, we don't deal that way. We only deal on an individual case. Now, I think your assistant told me, she says, no, they'll deal occasionally with those cases. I don't know. But it concerns me, you're right, and I think we both agree that if a doctor says the worker initially should be off work, that the board must accept that. And I mean, the employer has the right to challenge that from the employer side in a fair system. And I agree with that. If the employer says, well, we think you can work, we'd like the worker to be seen by our doctor and the board arranges it all fine, and then you go through the process. But to blindly say, no, I'm not going to accept this report or recommendation from a doctor, to me, that's a failed system. It's not working, you know?
It also goes back to when we had the person from the union, the head of the board's union. And the question arises, are the managers overturning decisions of the case managers purposely to pay less benefits? In other words, are the managers overturning decisions in both directions, or are the managers overturning decisions in one direction? And he didn't answer that question very clearly, but there's certainly an implication that the theme of the WSIB is uh, end benefits as soon as possible.
Yeah, like I would add to that and say that I don't know so much if the managers, in my view, are getting directly involved in the actual individual decisions so much as pressuring the case managers in these particular situations, like, for example, in the past pre-existing condition, to suspend benefits or reduce them. And to me, that's what I would call, and I could be wrong, is a covert policy, whether in writing or not. And that was proven in your case with Castrillo by the court, that the board was acting, what would you say, dishonestly or misfeasance or whatever by doing this. And if there's one, in my view, there's more. You know, and if some say, well, no, I look at the board's surplus monies, the billions that they claim to have. I also measure also when I look at the book Insurance Bad Faith, and in the book it says for private insurance companies, private disability benefits, that you denying somebody to be statused as unemployable is insurance bad faith. But yet the WSIB does it according to data from them. They've been doing it at a rampant level, you know, and I think
Maybe what
that's,
we should do for one of our podcasts is have somebody from the medical profession, the family medicine part of the medical profession, and come on the podcast and say, here's how I have to deal with injured workers in terms of diagnosis and work restrictions. So I'll
I,
leave it to my legal assistant, Pam Hughes Ford. If we can think of one doctor we see a few times, so we see a doctor who's handling working people and seeing workers' comp cases, maybe we can invite them on to get their perspective on a few issues.
I wish, I wish I still had my family doctor I used to see. She's retired. And she told me about a story where she attended a seminar for the WSIB for doctors. And the person running it was a doctor, I guess, or something. And they literally said that all injured workers were faking. And she just went, how can you say that? You don't know that. And it was just a very disturbing representation. The other one that would be good to have on would be personal injury lawyers in dealing with insurance, private insurance, because there's a very close parallel to private disability benefits and insurance law and workers' compensation. Workers' comp, you're injured at work, the board kicks in, covers you for the injury, everything. Disability, similar in ways. You know what I'm saying?
Well, you
To
know what
hear
I'll
from,
do is I belong to the Ontario Trial Lawyers Network, and there's complaints about their version of workers' comp, which is the LAT, where people get temporary benefits after a motor vehicle accident. So
oh
I'll
yeah,
find a
that's
lawyer who's been tussling with the LAT and have them on to give their perspective
oh
on what they're
oh
facing and why.
that's yeah, I wasn't talking about that, but that's a third one, which is the statutory accident benefits thing, which was created by David Marshall, the former president of the
Yes, I
WSIB.
saw that in your memo.
Yeah, so that's something to look. That's another topic that it gets off a bit from injured workers comp, but it what it does is it gives you a broader understanding of the systems, right? Like one that really opened my mind to how injured workers are not being treated fairly is when I saw the case of, oh, I can't remember, it went to the Supreme Court of Canada, and it was parallel to injured workers with how the board deducts CPPD. And in Ontario, if you haven't reached the lock-in period for your loss of earnings benefits and you apply for and get Canada Pension Disability benefits, the WSIB deducts it from your benefits. If you've reached the lock-in period, they don't. This was an exact same situation for soldiers who are injured. They have like workers' comp for them, not workers, but injured compensation for soldiers. So then they got together and they filed a class action lawsuit. Now, the case that I was referring to was heard with a case called Telezone v. Canada. And that case was talking about should an individual have to follow the administrative appeal route before suing for damages. And the Supreme Court said no, it would be a denial of access to justice because you have to go through one process, then the other, and it would be an inordinate cost of legal fees. So this case was heard with another. There was like three or four, and it was a really interesting parallel. But I would say, unfortunately for people like me, the case settled out of court because now you don't have anything to refer to or to reference. But it was interesting that the government did choose to settle the case. You know what I mean? Which is again
Well,
another topic about the CPPD.
we'll leave it there. We've got lots of future topics. Thank all our viewers for
Unfortunately,
participating, and see everyone next week. Thanks.
yes. Thank you.